Well, welcome to the after lunch panel. Our job is to get you past that sleepy state after lunch, and also to follow a great lunch speech, for God's sakes. That's really, anyway. But I'm Lucian Pera. I'm the president of the Tennessee Coalition for Open Government. I'm also a partner in the law firm of Adams and Reese down in Memphis. And for a long time, almost my entire practice, I've done media work, representing media in access cases and other kinds of stuff. With me today on the panel are Katie Townsend at my extreme left, who is the Director of Litigation for the Reporters Committee for Freedom of the Press. And to my immediate left is Frank LoMonte. He's Director of the Brechner Center for Freedom of Information. And before we get going, give us 30 seconds or whatever on what you actually do in real life and maybe what you've done, just to kind of let them know who you are.
Sure. So the Brechner Center, many of you are familiar with because you've worked with my predecessors, either Bill Chamberlain or Sandra Chance over the years. It is a think tank on openness and access in government. I've only been there for 2 months. I've gotten to know a lot of you in my other life as the executive director of the Student Press Law Center, which I did for almost 10 years. Student Press Law Center is a nonprofit, DC-based advocacy organization that works to improve the rights of student journalists at the college and the high school levels.
Cool. Katie.
The Reporters Committee is a nonprofit organization, for those of you who are not familiar with it, based in Washington, D.C. We provide legal services, training, legal manuals, guides, things like that for use by journalists and news organizations. We also provide litigation, direct litigation, representation for journalists, and pre-litigation legal advice to journalists and news organizations. We also do a lot of amicus work. I know I've done amicus projects with a number of people in this room, as well as policy work. So we're kind of a one-stop shop for journalists and news organizations when it comes to their legal rights.
And I think you also have a bunch of cool stuff posted on your website that journalists use every day.
We absolutely do, and to the extent that people are not familiar with the guides and the resources that we use, I encourage you to be familiar with them and use them. We have a federal FOIA guide, we have an open government guide, what we call it, for each state. It has information about public records laws in each of the individual states, as well as other types of guides.
So our job here today is to talk about developments in freedom of information litigation, mostly at the state level, I guess, but we may stray over to the federal level. So we got a bunch of topics in mind, but we want you to ask questions and whatever, and since the light is blinding us, you may have to wave wildly so we can see you, but there are mics circulating in the audience. But we were going to start talking about reverse FOIA cases. First of all, get everybody on the same page. What's a reverse FOIA case?
There are basically two kinds of what we would call reverse public records or reverse FOIA cases. The Associated Press actually recently did a great story on what I would call the first kind of reverse FOI cases. And that is where a government agency, in receipt of a public records request, sues the requester. So it turns around and sues the requester, or potentially just files a declaratory relief action where the requester is sort of the real party in interest, saying, we don't think we need to turn over these records. Court, would you rule that they're exempt from disclosure?
Why would anybody do that? Why wouldn't they just sit back and wait to be sued? After all, they don't want to turn the records over.
Why would the agency do that?
Yeah.
Well, there are a lot of advantages to doing it. One of the advantages to the agency, and I would say disadvantages to the requester, is the issue of fees. So we can talk about fee shifting. If you're in a state like California, for example, where fee shifting is mandatory, if you file a lawsuit if an agency denies your request and you file a lawsuit in order to obtain the records that are being withheld, if you prevail or substantially prevail, you're entitled under the law to recover reasonable attorney's fees and costs. Now, there is litigation currently pending in California to determine whether or not the same thing goes for reverse FOI cases. In other words, if you get beaten to the courthouse as the requester, are you still entitled to your fees? And that kind of brings me to the second form of reverse FOI cases that we're seeing on the increase or on the rise as well. And California is a good example because California actually prohibits under its case law the first kind. In other words, under California case law, a government agency cannot sue a requester. The government agency itself has to deny the request or respond to the request. There's an interesting little workaround we're seeing now develop, and this is when a third party, so not the agency, files a declaratory relief or another form of legal action against the agency to block disclosure. So there's a case right now that's pending in the California Appellate Court involving the Pasadena Police Officers Association, so basically the police union, who filed a reverse public records suit against Pasadena Police to prohibit the Pasadena Police from releasing an internal report about a police shooting that had been requested by the LA Times. The LA Times was successful in that case, and is now, the part of the case that's pending is whether or not the LA Times is entitled to recover its fees under the Public Records Act. So this is a sort of another form of reverse PRA in California, but reverse public records case that we're seeing that's really troubling.
Well, so go ahead, Frank. Absolutely.
Just to piggyback, I'm involved in one of these right now up in Wisconsin. But what's so scary about that second type is that without the participation of the news organization, the
All right, are we back? Oh, that one, maybe
things.
turned it off now.
Okay.
All right, well, but why don't you try continuing your
Try it
comment,
again.
and eventually someone will help us with
Yeah.
this.
I guess we could pass the hand mic if
We
these
could,
guys are
we'll
going to
see.
be a problem. But without the participation of the requester, the lawsuit is aggrieved third party v. government agency, which means that you don't necessarily have anybody in the case whose agenda and incentive is to disclose,
Well,
right?
Surely somebody who wanted to, either a news organization or a private individual who wanted to take the position of a requester, essentially wanted to vindicate those rights, could intervene, right?
You intervene, but to get back to Katie's point, as the intervenor, now you're not the plaintiff. Now you're not going to be entitled to the fee shift under the law anymore. That's the case we're working on right now in Wisconsin at University of Wisconsin-Oshkosh. Professors sues universities saying, do not give away my personnel file. Newspaper has to intervene to say, we think that the university may be less than fully motivated to vigorously litigate this, and certainly is not going to want to set a precedent that all their personnel files are open. And so you want a news organization in there to vigorously vindicate that point.
So are we seeing more of these? Is that y'all's view?
I think we're absolutely seeing more of these, and the problem with them is, one of the major problems with them is that they have a real chilling effect, I think, on particularly smaller news organizations and journalists, sort of scaring them into not wanting to submit a public records request to begin with. So under the normal course of things, you submit a public records request, maybe maybe you get a denial, maybe you don't have the resources to litigate that, and you choose not to litigate it. So the ball is really in your court as the requester to determine whether or not you want to
Well, it sounds like
follow up.
a bigger weapon against private individuals. I guess that's what you're saying, right? A private individual requester. So is there any protection under the anti-SLAPP laws for those folks?
So it's
Katie, excuse me, I'm sorry to interrupt.
Did you mute your mic?
I did
Yeah, we were
because it
getting
was making a
feedback, all of us.
terrible
No, it was my fault. I had
Okay.
It's
Okay.
always my fault.
All right.
Back here by the
Okay,
speakers,
well,
some
mine's
more.
back on. There we go.
Mine is too.
Hang on a second. What number is that?
One.
Okay. Give me a second.
Me too.
Yeah,
Is that okay?
yeah, we want to capture your all's audio, obviously, for this.
Okay.
Yeah, with that, exactly.
Very scared.
But just to Katie's point, I mean, to me, that's the most
You turn them on.
Term.
That's the most kind of worrisome and insidious part of this reverse FOIA
The
mechanism.
ability to use as a weapon
is-
against somebody without the means to defend themselves.
is that you lose control of making the decision whether these records are important enough to you to go to court over or not, right? I mean, normally the requester is the captain of that ship, meaning that I may decide either I don't think these are that important to me, I don't have the money to do this right now, or I think this is a gray area, this is not a great case on which to make precedent, right? And so I get to control that strategy decision. In the reverse FOIA, all those decisions are taken away from me, and now I've got to litigate it, or else I'm going to default. I'm going to set a bad precedent that way, right? So, yeah, all of the normal strategy calls that get to be made by the requester get taken out of the requester's hands.
And I completely agree. We just litigated, actually successfully, a case, we did it on a pro bono basis for precisely this reason, a case for a small newspaper in Camarillo, the Camarillo Acorn. It's a family-owned weekly paper. They were doing great journalism, and they requested emails between from the Camarillo Health District, public agency there, between its attorney and the former head of the district. The attorney, there was an internal investigation that the attorney was vastly overbilling the district. It turns out the district head who was approving those bills happened to be having an affair with the attorney. So the emails were obviously of public interest. They made a request, and the former health district CEO filed a reverse public records case against the agency to prevent disclosure. My client, the Camarillo Acorn, became the real party in interest and had to hire a lawyer. And they would not have otherwise been in that position. They may not have been in that position. I mean, I think ultimately it's great that they fought it. They won, and the emails were released. I think that was a great victory for us and for them, but at the same time, it should be their decision. And if they don't have it in their budget to pursue that, they may actually think twice next time about even making that request to begin with. And that's the real scary part.
Let's move on. We got a lot of topics we're going to talk
Can I
about.
jump
but
in? Because there's one case
Sure.
that people should be aware of. It's brand new. It's just a little glimmer of hope here if this is you and you're defending one of these. In a handful of states, there have been good rulings saying that because the statute says that the action has to be initiated by the requester against the agency, that there isn't a mechanism to do this. And ESPN just got one of those rulings against Michigan State University. ESPN was trying to get records about, and these are boilerplate public records, no doubt they should be turned over, about police reports involving athletes accused of sexual assault, and just a stalling tactic. The university decides they're going to sue ESPN. And the ruling just came back in the last month saying, no, the statute only, the door only swings one way in Michigan. This is a right that belongs to the requestor, and you can't short circuit it by initiating.
So that's
suit.
a question that's going to depend on attorney fee shifting statutes, probably the Public Records Act, in a very minute sort of lawyer-friendly way, at least. But let's move on to another topic, email. You mentioned, Katie, email. What are we seeing out there? What are the hot issues these days on email?
Yeah, I mean, the issues themselves haven't really changed. And I thought Jim McLaughlin gave an excellent presentation this morning about the DC Open Government Coalition's research on text messages. It basically applies to emails. It applies to all of the sort of electronic communications records issues that are out there. And the issues really are, one, there are the legal issues. And as Jim summarized, the law there is pretty good. In fact, I feel like I've been talking about California a lot, but I guess it's been active. There was a great case by the California Supreme Court, City of San Jose, earlier this year, where the court held that public records, so things that met the definition of public records that were on a non-governmental email account, so a private email account, but I put that in quotes because it was really a non-governmental email account that was being used
Hillary
to conduct
server.
public business, exactly.
Okay.
That those are subject to the California Public Records Act. And as Jim pointed out, that's consistent with the language of the Public Records Act. So it's not necessarily about establishing your legal right to email records on non-governmental email accounts or text messages on personal devices. The law is pretty good on that. Where the problem arises really is in the practical arena.
Well, we've had people, somebody this morning said, I mean, we've had people take the position that kind of private email account, city has PR person who works for the city, clearly a city official for this purpose, and they use their private Gmail account. And they put the city logo and everything on their private Gmail account. And the city's response to the request is, we don't know nothing about that email. It ain't our email. You go talk to, what's her name? And or Google, whatever it is. And I heard this morning discussion about whether that's a legitimate position or not, but it's certainly being taken out there in some places.
I think it's being taken, but I do think it can be confronted. In fact, there's, at the federal level, just I guess 2 years ago, there's actually now a federal FOIA case on this as well. I represented a media coalition that included a large number of organizations that appeared as amicus and actually argued before the DC Circuit as amicus as well in a case called Competitive Enterprise Institute against the Office of Science Technology Policy. This is exactly the issue that was before the court. Can the head of this agency sort of the Hillary server question. Can the head of this agency use non-governmental email account, in this case it was his former job's email account, to conduct government business? And if so, if he does that, is it subject to FOIA? And they said yes.
Well, but there is local law in every jurisdiction. Either there might be an absence of law, but about whether it is lawful for the government employee to do that, right? But so that's one question you get tangled up in. But isn't another question? Well, let's assume you can't, but they do, or there's no law, but they do, or they do it incidentally. I mean, I must say, I think it's a non-trivial, or it's not an illegitimate position on the part of the government to say, we have no control over this employee. I mean, that depends on what their rights are as an employer, right?
Well, it does, except it doesn't, because that was the exact question that was before the DC Circuit and CEI was, does the agency have control over those records? And that was the exact question. And the court said, well, we have control over the director of the agency, that's for sure.
Because of law that says they have control over the record.
Right.
But I can assure you in Tennessee, we don't have any law at all that suggests one way or another whether the agency has control.
Well,
so, I
or
mean, I
not
think
only-
that's not an obvious issue everywhere.
Not only law, though, I mean, I would think, and I'd argue it this way, that comes back to just general principles of employment law, right? Which is to say, I guarantee you that if that employee tried to abscond with the contents of that email account, which contain official government correspondence, that they would suddenly become records of the agency, and they'd be very possessive of those.
Well,
And so,
that doesn't answer
right,
the legal question, though.
I
think the employment question is kind of interesting, and because I've talked to some employment lawyers about this, it's not at all clear that private email incidentally used by an employee for employer's business is subject to the employer's control. Anyway, it's my opinion, maybe y'all can tell me I'm wrong, this issue is way far from settled.
I don't think it's the account. I think it's the messages, right? I mean, it's almost, right, if I put some recipes in there too, maybe we can argue over whether they have control over that.
Let me
right?
press you on the other question.
I don't think it's settled. And I should say, I don't think it's settled law in every jurisdiction. I think the law out there is pretty good. I mean, I think under the language of obviously every Public Records Act is different, but I think the definitions of public records are generally broad enough to capture anything. And they're also, they don't necessarily just apply to the agency. Many public records laws are written to apply to a public official, himself or herself.
Right.
The real problem that
Which
we're running
would get around the
into-
employment issue is your point.
Exactly,
Yeah,
because they're subject to it themselves.
Right.
The real problem that we're seeing is really, as Jim said, really the practical problems of, we have a case that we've been litigating for years. I think Paul this morning, who was from Oklahoma, our case, this is an Oklahoma court against the governor's office and the Department of Public Safety, and it addresses the issue, one of the issues he raised today about the prompt and reasonable standard. One of the issues that came up in that case is, in that case, the client, which is the Tulsa World, and one of their former reporters, a woman named Ziva Brandstetter, she had requested email and had specifically stated, and that I want email regardless of where it is. If it's on a non-governmental or personal email account, that's included within my request.
Practice tip, always do that.
Yeah, it's a great thing to do, although at the same time, we learned that only through discovery, we repeatedly asked the governor's office whether they had searched non-governmental email accounts. And we learned through discovery that the governor was in fact using her non-governmental email account because they forgot to redact some of the examples of her non-governmental email. We filed a motion to compel a search of her non-governmental email, but at that point, the litigation had been going on for a year. And
you're telling me government officials would lie in litigation
And,
about their records?
shocked.
I am shocked.
Shocking. And so it's those practical problems,
Yeah,
I would
yeah.
say, that are really the issue. Because if you're in litigation, at least you have mechanisms to force something to happen. But if you're not in litigation, if you just make the request, how do you really
How
know?
do you know? Well, let me flip the issue for a minute, because this was mentioned in passing this morning. Let's assume that I'm on the city council, and I'm issued a fancy new iPhone from the city, right? And I'm using it for, shopping lists and, my financial stuff and my kids' baseball pictures and all that sort of stuff, as well as my mail. Why isn't every bit of data on that phone, why didn't it belong to the city?
That's a city-issued phone, you said?
Yeah. They own the phone, they bought the phone for me, they gave me the phone, I'm using the phone. Why isn't everything on there, including you know, the naked pictures I have of my girlfriend. Not that I do, okay? Not that I'm just saying, just a hypothetical. Dear God. Anyway, but you get the picture.
It
Hopefully
is.
you
I
didn't
mean,
get
I
the
think
picture.
we would argue, and I think this is actually goes to best practices. I mean, whenever people raise questions about privacy, issues of privacy,
Right.
I mean, my response to that is always, well, what are your records policies? Do you prohibit your employees
Right.
from using their government email and their government devices
but-
for personal stuff? You should tell them that there are consequences
Well, but
for
let
that.
me, maybe this, I live in a different world than y'all do. I don't think I do. But let's assume they have a great policy. You wrote it. It's a brilliant policy. Thou shalt not use your city-owned cell phone for anything personal. Anything you put on there that's personal, the whole world can see. Right. Doesn't that person still have some kind of privacy interest in some of the stuff on that phone? If he's got his medical records on that phone, you know, you're screwed getting
The
a hold of it.
Supreme Court
Right.
has had this case.
Yeah,
The
it's a
Supreme Court has had this
standard
case.
reasonable expectation of privacy, and,
The-
and if you file if you get an employee manual that says, by the way, your employer can look at this at any time, and you work for a government agency, and it says not only can your employer look at this at any time, but you're subject to the Public Records Act. This was exactly the case we ran into in the issue one of the issues we ran into in this Camarillo case I just talked about. She argued this is private. This is private discussions I had with my paramour, I guess. And this was on city government,
Right.
her governmental email account, her governmental cell phone. There were voicemail messages on her governmental cell phone, and she said that she had a privacy interest. And we showed her the policy manuals and the employment contract that she signed. You can't have a reasonable expectation of privacy.
Yeah, this is the City of Ontario U.S. Supreme Court case where they said it was a police officer that was using a city device to text with his girlfriend, and this was discovered as part of a routine that the city was trying to see because they had a through-the-roof data utilization bill, and they were trying to
Right.
see who's running up all these minutes, and they looked in the phones to see, and it turns out, right, he's been using this for personal use, and Supreme Court says no expectation of privacy in that. So, right, I think, but I'm going to give you the Bill Clinton answer to your question. It depends on what your definition of on is. Because I really think, right, that when you say on the phone,
Right.
On the phone
right.
could be, right, if it lives in the device so that my employer at any time could reclaim the
Well,
device
it's
from
funny-
me, right, with
it's
all
funny you
those
mention
things
that.
that live in it, right, just like the hard drive of my desktop computer, I'd certainly take, and I think the employer would too, the position that everything on there certainly is. But
Yeah.
if it's a cyber account, right, where is that on there at all?
Well,
That's where it gets tricky.
I
right?
just footnote two different scenarios there. One is there's nothing in the world that's just on your phone.
Sure.
It's somewhere else. And that's, I mean, I help run the technology for my law firm, and it's the bane of our existence because, you know, that means that we got client information likely on God knows how many services, who knows where, because the people I worry about are the careful ones, the ones who are backing up their phone all the time, right? And the default on an iPhone these days, as I recall, sends you to the Apple out, what is it called, iCloud or
Yeah,
whatever?
iCloud, yeah.
It sucks. But in any event, the other, well, it sucks in the sense that you have no control. An ordinary user of a cell phone has no control of where their data is. But for this purpose, it means that to get that public information, you might have options other than just
Yep.
the phone, right? Isn't that the point? One of the
Certainly
points.
DOJ has all kinds of options.
Oh, right.
But I,
They've demonstrated.
right.
Yeah.
Okay. Well, and by the way,
Oh,
one
oh.
other detail, just to complicate things one further bit. Many systems now have it's called mobile device management, and it will. The easiest way to understand it is it builds a sandbox on your iPhone and puts the stuff that's the company's in the sandbox, and everything else can be yours personally. I don't know if governments have gotten that savvy yet, but it gives the person who runs that sandbox, namely my law firm or the government, the ability to go in and protect things, back up things, and I think maybe have you another alternative too in terms of getting at the information. Point is, there's nothing that's just on a phone.
Sure,
Anyway,
sure. Well, the one issue, and Jim did flag this a little bit, but just for the folks who are, advocating at the legislative level, I mean, I think where a lot of action ought to be, I'm sort of disappointed that there's not more action on it, is on the retention issue, because
absolutely.
especially as we go to these more ephemeral methods of communicating, right, that's really where the rubber is going to hit the road, is are you retaining these, and are you retaining these in a way that's actually readable to somebody that doesn't have the same technology that you do. But there's a practical reason why we don't see those litigated. A, you don't know what you don't know, right? So how can I sue you for things that don't exist
Well,
anymore?
yeah.
But also,
Whoa, what the hell was that?
people on their toes, right? Yeah.
Also,
I think you're the one who's setting off the screen.
maybe you're
Go
right.
ahead,
I mean,
go ahead.
I just flipped it.
It's
one
your
way.
controversial comments.
Once you realize as the requester that the records that you want no longer exist, then it is really hard to get super motivated to spend the next 2 years in court proving
That's
an
right.
abstract principle, right?
Yeah,
So
one-
that's why these cases sort of evade litigation for that reason. We're fighting over nothing, a literal nothing.
One further comment on that, we'll move on, and that is that one thing I found, not necessarily in the media work, but is that a lot of the data you want lives in a lot of places, and that the best reporters wind up going and looking for it in those multiple places, and that certainly is true in this arena as well, right? Yeah.
One more comment, which goes back to the point you made earlier, Lucian, which I think is absolutely right. When you're dealing with this mix of public and private content on a government-owned device, it's a little bit more straightforward. I think where it's far more difficult.
And it should be.
And it should be.
Because it's a government, whatever.
Exactly. And I think where it becomes more difficult, and where I think the more difficult legal battles are going to be fought, is this question of using non-governmental either phones or devices or non-governmental email accounts to conduct public business, because courts are wary of that, and, obviously, because they don't want to have a situation where we received a public records request, everyone's Gmail account is now going to be searched. So the questions, I think, are going to revolve heavily around, and we saw this a little bit in the CEI case at the federal level, but I think it's at the state level as well. I think the questions are going to revolve around, do you have some evidence that this person is using non-governmental email account to conduct government business? Can you demonstrate that? Can you demonstrate that they're not complying at the federal level with the Federal Records Act requirement that they create a public record if they use a sort of governmental means of doing so? And I think those are going to be the more difficult questions, because as Frank said, you don't know what you don't know. So if someone's using their non-governmental email account all the time, it may be difficult to find that out.
Let's move on. I'm going to try turning this on again, see if it explodes. It didn't explode. Okay. Student privacy. Tell me what's hot in student privacy. You've got the deepest background on that subject of anybody I know. So tell us what's hot the last little while.
There's actually a lot going on, including a ruling just came down this past week that unfortunately went the wrong way on disclosure. But so many of you who've worked in this area know that if you try to get just about anything at all these days out of a public university or a public K-12 school, you're going to run into the student privacy objection, even quite frankly if it's something that's just a harmless piece of de-identified statistical data. Columbus Dispatch did a piece about this recently where they tried to get from school districts around the state of Ohio, how many times were guns brought into your school? Not the names of the people, how many times, well, just the statistic. And many of the districts responded back and said, well, that number is so small that we think the number might be matchable to individuals, and therefore you cannot have the number. And the default position of the district was that, which, I mean, right, logically it doesn't hold together at all. It makes no sense. But the default position of the districts was that if it was anything under 10, that you couldn't have the number. Well, I don't know how many of you have kids, but if your kid's school had somewhere between 1 gun and 9 guns, I guarantee you that's a material difference to you. That is a significant difference, and it's one that you have a right to know about, right? But because of this kind of great and powerful Wizard of Oz FERPA that turns out actually not to be very much behind the curtain at all, people go into immediate duck and cover mode. So just a couple of points on this. First of all, every practitioner should know that FERPA is an empty threat that has never been enforced against any educational institution in 43 years and counting. And so this
empty threat, by which you mean nobody from the federal government has ever come in, with a SWAT team and shut down some university because they let some students' data out, or otherwise punish them, I guess.
Otherwise punish them, because there is a mechanism set forth in the Code of Federal Regulations that says before punishment can be imposed, the Department of Ed has to make a finding that you have a policy and practice of giving away your students' records. No one has even gotten that far, let alone to being fined anything. And so it is an empty threat, but one that is invoked, oftentimes frivolously. And my favorite story on this, and this is my university, by the way, it's the University of Florida. I'll tell a tale of my own school. They had a fraternity hazing case recently where folks asked to see the investigative records once the investigation was over with. University goes through and redacts it out. Well, so the hazing involved a prank where you had to carry around the watermelon like it was your baby, and you carried this watermelon around 24/7. They gave it a name, and then if you were caught putting the watermelon down, Gallagher style, they would theatrically get a sledgehammer and smash it all over you, and then you would have to endure some other indignities after this. And so the university gives over redacted copies of these records in which they take all the names
Wait,
out,
how do they have records of that?
including the name of the watermelon.
Oh,
Including the name of the watermelon, which, by the way, was Walter. Spoiler alert.
why do they have records of this?
Because the university does an internal investigation to discipline the fraternity, right?
Or
And so
that kind
people
of
want to see, right,
okay.
did the fraternity get it? Anyway,
That
so
may explain a lot about higher ed these days.
that's the kind of overzealous use of student confidentiality. But two things on this. First of all, there's good authority in the CFR and in the Department of Ed's own interpretations that it's a good idea to have to show to your clients. The most important thing for your clients to know is that FERPA is about the record and not about the information. It is a record privacy statute, not an informational privacy statute. And the U.S. Department of Ed has said that over and over again. What does that mean? That means that if I know something from personal experience or observation, I can tell you. If your camera crew for the TV station goes down to the school and they say, we understand that Johnny was arrested for bringing a gun into school, what can you tell me about Johnny? As a teacher, I can tell you, oh, Johnny was a stellar student, always stuck up his hand to volunteer, one of my very favorite students, everybody loved him. All those things I can tell you because I'm not reading them out of his education records. I'm telling you that from personal experience and observation. None of that the Department of Ed has said is covered by FERPA. Only those things that are in centrally maintained records. So what's going on in the courts about this? There's a couple of cases to watch. Big one out of University of Kentucky, which is a reverse FOIA suit. University of Kentucky is suing their own student newspaper, trying to withhold records of sexual harassment cases against professors. Obviously, students are implicated as witnesses there. They're saying that because the students are the witnesses, these are student records. That case is on appeal right now. North Carolina, very similar one, only not a reverse FOIA, involving, in that case, the outcome of disciplinary cases where people were found liable for having committed a sex crime, and the university claimed that they can withhold those under the federal FERPA statute. We think that it's very clear that they can't do that, but that's also on appeal right now. The one that just got decided, and this is a recurring issue that the feds need to clarify this because the authority's all over the map on it, but there's just a bad ruling day before yesterday out of Minnesota involving one of these surveillance camera videos, and this is a recurring fact pattern. TV station will want to see a surveillance video out of a school bus or out of a hallway, and the school will claim FERPA, and you can find a case that says anything you want. There's New York and Louisiana have cases saying give it over. Utah and now Minnesota have cases saying don't give it over. There's one pending in Pennsylvania where trial court said give it over, but it's on appeal right now. And so we just need to get clarification on that. The challenge is, right, because you're always asserting a right under state law, it's almost impossible to get the U.S. Supreme Court to weigh in, and so you're just going to have this patchwork of authority until we can get the...
Let me ask a practical question. The practical question is, and we deal with this some, I mean, what do you do? What do you do when, the university won't give you the barest information on that grounds? They won't give you a redacted police report or whatever it is from the campus police. What do you do? How do you deflate the FERPA dodge? I mean, tell us some practical stuff. What are the best sources? What's the best argument? What's the best way to get this university council to see the light of day?
And feel free to jump in. My most effective one is that you can almost always find examples elsewhere of the very same record having harmlessly been turned over, and that school is still in business and still receiving federal funding. That's always the most effective one. We had a case involving fraternity disciplinary records, this is in Florida, where the institution was insisting that these are all covered by FERPA, and we found found that, in fact, the Arizona Republic had a database of these very same records that they had gotten from every college in Arizona that was living online. And in fact, South Carolina has a statute now, after they had a hazing death there, that says these very same records that Florida is insisting are confidential under federal law have to be put on the web in South Carolina. And so state law mandates the affirmative production of these records that Florida was trying to insist are protected by federal privacy law. So that's the number one thing. Is just look around the country. You're often going to find an example of people harmlessly disseminating the very same records that people are trying to claim. The other thing I would say is FERPA is a door that swings two ways. It is both an access statute and a privacy statute. And what Congress has said is that if something is a FERPA record for confidentiality purposes, that it is also a FERPA record for my own personal access purposes as a student or as a parent, meaning everything that they categorize as a FERPA record, they better be ready to turn over to me when I come to the registrar's office and say, I am here to inspect my own FERPA records. And sometimes just exposing that hypocritical double standard works, because they know very well, let's use the surveillance videos, right? That if I come to the dean's office or the registrar's office and I say, I'm here to see my FERPA records, they don't say, hold on, we're going to look at the last 6 months worth of security videos to see if your face is on there, right? They know those are not FERPA records when I show up to inspect them, and they're not prepared to treat them like that when I show up to inspect them.
Okay. Anything you want to add? Yeah.
That's exactly right. I mean, I would just add, if you're looking for resources in this area, the Reporters Committee for Freedom of the Press has guides that address FERPA. I would say the Student Press Law Center amicus briefs that they post on their website. We've joined a number of those amicus briefs, and so they're on our website too. Those are good places to look if you're crafting a letter responding to just that kind of denial.
Questions? We've been moving kind of fast up here. Anybody? Sir? Hang on a second.
To Frank's point, text messaging and ephemeral records.
Sorry.
That it's hard to capture those. Either they are automatically disappeared by the person holding the cell phone or whatever, or you don't know what you don't know. Do you have any good examples of jurisdictions, governmental entities, particularly in the case of personal devices that may be used for government purposes? I mean, we're seeing, I've done some work, and we see instances where, like, police folks, rather than use police radios, are using private cell phones to text back and forth or to communicate, and it's virtually impossible to capture that unless the only access is if you do get a third party who got one of those messages, and then you can back into it, but still it's hard. Are there examples of jurisdictions that have established good policies in terms of employment requirements that you may not use this device for your public work, or that that there's a retention policy that your device has to be enrolled in a collection process so that you know that we have all your text messages or whatnot? Because I don't know how you stop that otherwise.
I mean, I think of the best example for retention purposes as probably being the Federal Records Act as it was amended to cover essentially email, although I think it covers pretty much any electronic record. So it requires that if you use, it doesn't prohibit the use of sort of a non-governmental email account, but a non-governmental device. But what it requires is anything that meets the definition of a federal record, and this is an employment requirement, right, for federal employees, anything that meets that definition then has to be, if it's an email, forwarded to some governmental email account or otherwise recorded. So if it's a text message, there was a funny tweet going around, I don't know if people saw it, about a phone that had been photocopied because someone had requested text messages. It was sort of a joke, who photocopies a phone, but at the same time I was like, well, at least they're giving them the text messages. If that's the best way to do it, at least you're doing something. There's got to be some, and I think there are practical problems in terms of electronically recording text messages, right? But even if that's a sort of low-fi way of doing it, it's better than nothing. So that's one retention requirement that I think is good. There are other individual public agencies at the state level, I'm trying to think of an example, that do, as a matter of policy, prohibit the use of devices for public or for private use, right? So if you get a governmental issued device, I think that's not uncommon actually. It's that people don't really abide by it. But I think if agencies made it clear that this is not just good for people who want compliance with the Public Records Act, this is actually good for you, employee, to keep your private and public communications separate, I think that would be enormously helpful. And but I think that there has to be internal agency. It's not just policies, right? It's compliance with those policies and an agency making sure that their employees actually comply.
Yeah, the truth is, I think most organizations, certainly most, private or public organizations have a policy that certainly says, that you use the government stuff. There are many that have the other kind, the other wing, the other part of it that says you can't use somebody else's device, private and public. But the fact is, they're unenforceable. I mean, in human life, it's not going to happen. We've had email for more than 20 years, 23, 24 years. And throughout that whole period, everybody has used their formal email, their business email for grocery lists, and their private communications devices for work. I mean, that's what happens. And, yes, sometimes it's done intentionally. That's why you see, we're going to talk about investigations of police-involved shootings. You look in a police investigation where they're involved in misconduct, you will see their private phones scraped as well. So I'm sorry to be a naysayer or whatever, but the moral to me is less about the law. It's more about when you want it, you got to be smart enough to look for it in the right place, and in places you don't know exist. Right. But that's the sorry truth.
I just can't imagine. And this is, the hell of this is that the higher ranking you are and the more important you are in any agency, the more that you're on call 24/7, right? And so unless agencies are prepared to issue official business devices to all their employees, which relatively few are, some of them will, but relatively few will, right? So they're not going to honor the policy either, right? If I'm the city manager, I'm on call 24/7. The mayor is going to be texting me, hey, we had a water main break in the middle of the night on Saturday, right? And I'm going to be expected to respond to that text in the middle of the night on Saturday. They're not going to wait for me to check my government email. And so, that's the sort of, the paradox for reporters is the people whose messages you most want to see are the people most likely to be getting on personal devices in the middle of the night on a Saturday, because that's just they're the people with the most responsible positions.
If you wanted to look for guidance on this or best practices, if it were me, I'd look at the securities industry and I'd look at the health industry. And even, I've dealt with some people in the securities business, and they're the two-phone people, right? Yeah. Because, they got to do it according to, and there are regulators who come in and check whether they've saved all their, they can only IM on, approved devices that back up, on the firm system, and they got to keep them for how many months. And HIPAA has teeth, and doctors and hospitals have real policies about that, but I'd be willing to bet, and I'm pretty sure, that you're still going to see, if you're investigating a medical malpractice case, you're going to see that the radiologist got a cell phone call in the middle of the night when somebody questioned their radiology finding and the patient's in trauma or whatever. So I just don't think there's any realistic answer here to that from that perspective.
This is where we need to get Apple here next year and get them to design the G phone, where it's a government phone built for government that backs everything up to the FOI compliance officer immediately instead of going to the
iCloud.
That's
because we don't have enough total information awareness, right? Okay. Oh, God, my head is starting to explode.
Yeah, a bunch of questions.
I'm sorry. I forgot. Sorry.
This is a follow-up, and you may have just a second. Are there any? Are there any model record retention policies that you're aware of respecting text messages?
Specifically that are specifically including text messages, not that I can think of. That doesn't mean it doesn't exist, but I'm not aware of any. In fact, most state records retention policies are pretty outdated, I would say, that we've seen.
Yeah.
And they are still problematic with respect to email, some of them. So in terms of just expressly addressing what needs to be done with respect to certain types of technology. So I can't think of any, but if anyone in this room has examples from their state, please. volunteer that information.
See a hand back there on that question? Okay, hang on a second. Back here in the back, and then we'll go.
Yeah, let's.
I'm not sure if you've seen this anywhere else. I'm from Illinois. We're involved in a case now with the Supreme Court. There's a phrase that we've adopted: break the law, change the law. A FOIA was submitted. The district court said, give them the records. They appealed. They went to the legislator, changed it, made that specific record exempt, even though they didn't say it was retroactive back to any given date or time. And now it's before the Supreme Court. Are you seeing legislative action anywhere else in that regard?
I can tell you one story just exactly like that, which was in Indiana. Student Press Law Center has been working for a while to try to get access to the records of police agencies at private universities that exercise sworn law enforcement authority. And so Dennis mentioned the Otterbein University case earlier. That was a case involving that exact fact pattern. Private university takes on state law enforcement duties and responsibilities but doesn't want to obey state disclosure laws. Ohio Supreme Court says you have to do it. Parallel case went against Notre Dame in Indiana, and on the verge of Notre Dame being ordered to turn over the records, the Indiana legislature creates a sweetheart statutory exemption that end runs the state court of appeals, and so that's now the law in Indiana.
Hang on a second. We have one person back in the back.
Yeah, I think. Did you want to add something to that?
I was just going to add, I know exactly the case that you're talking about, and it was a bad ruling at the intermediate appellate court, and it was pretty strong dissent, though, and then cert was just granted by the Supreme Court. It's really policy-wise terrible, and I hate to push everything back to fee shifting, but I think it's a huge fee consideration as well. If you have a slam dunk case that you bring through the, you say you're almost to the end of the case, and suddenly the legislature decides they didn't like your request and changes the law, and suddenly you lose, that could put you in a really difficult, you can't recover any of your fees. So I think that's one reason it's very concerning. That being said, it has been it's not, I'd like to say it's unusual. I wouldn't say it's a huge trend in the sense that I'm not seeing it happen all the time, but it's certainly happened in the past. It's happened at the federal FOIA level as well.
Right, remember the Dale Earnhardt one, right?
Yeah.
That was, and this is going back decades now, but the Dale Earnhardt case in Florida where they took autopsy photos off the public record because of a particular case. So yeah, right, this is not something novel for this generation.
Back in the back.
Hi, this is Alex with New York. So my question is, what are in your experience, based on the cases you've seen, in what circumstances can you request, looking at a government employee's private device? I mean, if you don't have proof, if you don't have evidence that there was an email, because we've seen cases where someone will do a FOIL of a government employee of their government email, and there are no emails. And they might claim, I did everything on the phone, but I don't know if that's enough to then say, well, look at their private devices.
I'm the one who's. I've run into specific cases of the government saying, we don't have any, and talking about in this context. But I mean, why can you not just make the request of both the agency and the individual? And if they want to say there are none, there are none. But they've got a duty to respond to both, is what I'm hearing from the rest of the country, right? I mean, if you don't know, that you can ask, right? I mean, there's nothing wrong with making a request for documents of somebody's every device owned or used by this individual and make it to them individually. Because many states' laws are directed, as you pointed out, to the individual, right?
But yeah.
If the state law also covers a public official as well as a public agency, you could do that. Although you can make the request to the agency, I would just be very specific in the request, as we mentioned earlier, to say, I want all communications between so-and-so and so-and-so from this date to this date. This request includes text messages, regardless of whether they were sent on a governmental device or a non-governmental device. Non-governmental email. Just make sure your request covers everything, because I will say that makes it far more difficult for them to deny you without conducting at least an inquiry, let alone a search of those sources that you're specifically asking be searched, right?
Specifically asked, they have to specifically answer on most jurisdictions, I think,
Right.
So they're going to have to say, we haven't looked at the individual's phone because we don't believe we have the right.
Right.
And then you got a red flag, right?
Yeah. And I would say in terms of success rate at the litigation stage, in terms of getting access to this type of material, I think you're going to have traction with a court, fortunately or not. I mean, I think the state of affairs, practically speaking, is that you're really not going to get a lot of movement on that unless you have some indication or evidence from somewhere that this person is using their non-governmental email account. Now, the funny thing is that when officials use non-governmental email accounts or they text message, they're probably doing it with reporters too, and I mean, it may not be that difficult actually to find evidence that someone's not solely using their government device or account. That being said, I don't think personally that you're going to get much traction with the court by just saying, well, I think they should have to search their private phone, even if I have no indication that that they actually use it for their government work. I think that's going to be a tough argument.
Hi, my name is Mike Riker. I'm a reporter here at the Tennessean, and I work a lot with government data, and I'm wondering what type of movement you've seen nationwide at the state level to increase access to data, and specifically in raw data, right? I like to be able to run my own analysis, and also dealing with some of the costs for producing that kind of data. Governments like to claim it's very time intensive when it often is not. So wondering if you guys have some experience with that.
I'll start off, but I bet you have something to contribute here too. I mean, two things. So if you heard earlier, you heard the presentation from Colorado. They now have what I think a lot of people are going to consider an optimal statute about producing data in searchable form, because there's all kinds of horror stories, right, of people who ask for data and they'll get a PDF of a database that's not sortable, that they can't do anything with, right? And sometimes that's on purpose, that the agency doesn't want you to sort it, right? And so I hope that's going to become the industry standard. I was involved in a situation a couple years ago in Georgia where the agency literally told the requester, I'm sorry, but the data that you want is embedded inside of a piece of proprietary software that is not readable on your computer and not exportable into any readable format. So sucks for you, but this is public record that has been walled off by our chosen use of inaccessible technology. And our response was, no, sucks for you. We'll see you at the legislature. And we got that codified, that you cannot any longer in the state of Georgia. And that's Oregon has that now. A handful of states have that, saying that you cannot wall off otherwise public data by utilizing a piece of software that doesn't export. And so you're just going to have to build that into your RFPs for software going forward, that nope, this has got to be something that I can turn into an Excel, or I can turn into something that's actually readable by somebody who doesn't have that program.
But that then, I'm sure you've seen this, I mean, that then leaves you in a problem. Fine, it'll export it. What'll export it into? Because inevitably the person running the software has all kinds of choices, right, about how to export it, right?
Yeah.
About how to export it and then what forms to export it, so that it might be useful to you, right? And here in Tennessee, we've got no law that suggests that we've got any particular right to get it in any particular format in that way. So, I mean, there are all kinds of problems. I'd be interested to know how they do that in Colorado, but just because it's searchable doesn't mean it's able to be searched, given if you're exporting it from a piece of software.
Right.
I would just add to that, I think that is an increasing problem, and unsurprisingly, both legislation and government agencies sort of at the practical level are slow to respond to not just the changes in technology, but frankly the changes in journalism. I mean, data journalism couldn't be hotter right now. And so we get these questions all the time from journalists who will say things like, I've asked for this information in this format, which I would always say people should do. They should ask for the information in the format that they want it to receive it in, and be willing to kind of work with people at the state level. But in terms of, is this a growing problem? This is a growing problem. One of the things that Frank alluded to that I think is also worth noting is that a lot of these systems are third-party proprietary systems. And so you can run into situations where it's a common technique for data journalists to make an initial request basically for kind of categories of information or structural information about the system, right? So then they can figure out how to best structure their request, their larger request for the actual data. So they can be more specific about what they want. We've had even those initial requests, or we've seen those initial requests be denied in sort of a reverse FOIA world, because these agencies will say, well, we've asked our vendor who provides this, and they consider that trade secret protected business information. Like, we're not going to give you this information. And so that's a huge hurdle as well. And I think that one is going to play out in litigation. But I think in terms of, or at least I hope that it plays out in litigation in favor of transparency, but I think that what you're going to see, another issue you're going to see more of, is just this practical problem of trying to deal with getting the data in the format that's usable, and trying to get it from agencies who, one, they don't have an incentive necessarily to do that, but they're also hugely reluctant to do what feels to them like opening up, the front door and inviting you in.
I think you may be being overly charitable, perhaps, because I was going to say, our experience is that it's a great dodge. They do not want to do anything like presenting it in the format that it would be most useful. But the other thing, as a practical point, and I bet you would agree with this, the folks who do this kind of data reporting who are best try to find a way to actually sit down with a human being and have a conversation, because what Katie's describing, we do in discovery a lot, right? You make a formal request. It can take forever, and it doesn't work very well. And if instead you can get to the right person and sit down and have an actual conversation with a human and say, oh, look, this is all I'm looking for, and they can say, oh, well, in that case, maybe we can give you these 14 cells or these rows out of a spreadsheet, and will that be enough? Well, give me one more, and that'll do. That kind of conversation is what goes on for folks like you who do get what they want. Now, that, of course, assumes you're going to have cooperation, some level, but if you can make their lives miserable if they don't, which sometimes you can do, then sometimes that leads to that kind of conversation, in my experience. Yes?
I think I'm next.
sorry.
So, Katie, you mentioned the Open Government Guide. It's still in the process, I think, of being updated. Do you know when it will be updated? Because what you guys have now is 6 years old.
I know. They are in the process of being updated, and we work with people within the jurisdictions to help us update those. So it depends on the state, frankly, when it's going to be updated. Some of them have been updated more recently than others. The federal FOIA guide, our plan is to update that this coming year. So I'm hoping we have a new edition. I do know that they're not as up to date as they should be, but yeah, we try. And I would just add too on the fees issue, on the data journalism point, that costs and fees are obviously a huge issue there. It depends on obviously what under your state public records law an agency is even permitted to charge you. But if they can charge for things like that are more vague, other than just copying, but if they can charge for things like processing or programming or searching and things like that, and reviewing and things like that, particularly for a data journalist, that can mean huge costs and fees. And I think those are situations too where it's, from a practical standpoint, we recommend people do exactly what Lucian suggested, that you try to figure out how to get those costs down.
You may be able to. I've seen people hire folks to help them do that. Hire a consultant that's worked with this kind of software to draw the information they want out of it, and be willing to bear that cost because it's quicker and cheaper than fighting for years. So do we have another question over here? Because I want to move to the last topic.
I just had a real quick question back on data format, and when you're talking about record layout and getting to those cells and the spreadsheet that you want. In Texas, we tried to address this in the legislature this year, and we got a lot of pushback from our Attorney General's office, IT, well, not just the IT department, but they called in their IT folks and said that, well, what you all are asking for presents IT security risk, infrastructure risk. And of course, we had our experts, guys who do this type of reporting, and others, even in the legislature, who said, no, it doesn't. It's just like a table of contents. But how often have you run into the IT security argument, and what's the best response?
My people have heard it, and anyway, that's all I can tell you. We've heard that for sure.
Yeah, I have too. Sometimes, right, with some of those things, it's a matter of trying to demonstrate how many peons in that agency have access to this thing, so that you can show that, in fact, you don't maintain this in the way that anybody would actually maintain national security secrets.
Or that you're not asking for stuff that really does threaten security. Or threaten security in a sense of data security or something, that you're not going to change it, or whatever. I mean, that's why I say between having a data reporter, for example, who knows what they're doing, and then maybe having to hire somebody who knows how that software works, that sometimes can lead to a conversation that can get you to the end much quicker. Anyway, let's move on to one more topic that's a really hot topic, which is some law enforcement issues. Let me kick off maybe on this one. I heard some of these discussions from other states this morning and was a little disturbing. My love for Deborah Fisher and Frank Gibson and others has even grown. We got something done this year. It wasn't entirely the TCOG, but nevertheless, we had changes worked into the law concerning, and Deborah's going to have to correct me if I get this wrong, but on body cams and on police-involved shootings, the short version is that on body cam footage, it's now a public record for sure under the black letter of the statute. It also, however, there have been privacy exceptions explicitly laid out in the statute. There's one of them about students in certain schools. There's some about medical facilities, I think. There's one of them about homes, interior of homes that aren't crime scenes. Anyway, and then I'm trying to think what else on that one. Oh, the other one, that's the one where they put a sunset provision. I don't think we've ever had a sunset provision on a public records law, and it says it lasts till 22 and it goes poof. On the theory that they don't know all the right answers, that this is a hot area. It was an act of amazing humility on the part of our legislature, not known for its humility. But the second piece was police-involved shootings. Several big, I guess it's Memphis and Nashville, have contracted essentially with the Tennessee Bureau of Investigation to do all the investigations on their police-involved shootings for conflict of interest reasons, obviously. And the problem is the TBI, as Deborah said this morning, has the deepest, darkest, forever blackest public records exception known to man, at all. And this doesn't work then for accountability on police-involved shootings, right? So the law now says that once they do an investigation, that entire investigative record, including the body cam stuff, becomes a public record after all prosecution functions have ended. In addition, during the time that they're pending, there is some discretion on the part of prosecutors to release this information, and that actually grows from a really weird couple of lawsuits in Memphis where the DA wanted to get some of this stuff pushed out and went to a chancellor and convinced him that that deep, dark TBI public records exception allowed him to release it, which I don't know anybody who believed that before the chancellor said that, and they got released. And so since a law enforcement official had said, yes, this is a positive thing sometimes, that was written into law. Is that a decent summary? Deborah's nodding, so we're okay. So that's what we're up to. Tell me what's up in the rest of the country that y'all have seen.
You want me to start? So I don't have to tell anybody in this room that access to law enforcement records is one of the more difficult areas, I would say, in terms of the calls that we get at the Reporters Committee from reporters who have been denied access. That is usually at the top of the list in terms of what they're trying to get and what they've been denied. Areas that we're seeing, body camera footage is obviously a hot area. We aren't seeing case law necessarily on it, which may be a good thing. I tend to think it's probably a good thing that we're not seeing a lot of litigation about it, but we are seeing a lot of movement in different legislatures. I think my colleague Adam Marshall was on a panel last year that spoke about the Reporters Committee's sort of research work on body camera footage. So we have a map that kind of tries to keep track as best we can of legislative proposals and legislature and the state of the law in different jurisdictions on access to body cam footage. It is a little bit of the wild, wild west. There are a lot of jurisdictions, because this is often done at a law enforcement by law enforcement agency basis, there are a lot of jurisdictions with no policies, not even policies, on body camera, use of body cams and access to body cam footage that are adopting body camera programs, which can be good, it can be bad. It sort of depends. We are seeing that where jurisdictions are looking for legislative solutions, they tend to be pretty restrictive. We had a situation in D.C. where, notwithstanding the fact that the mayor touted the D.C. body cam program as going to increase transparency and accountability with the public, quietly slipped into a budget bill full-scale exemption for under DC FOIA for all body cam footage. The Reporters Committee, as well as DC Open Government Coalition, complained loudly, as thankfully did some of the city council members from jurisdictions within the city, who said that's not the point of this program, and DC taxpayers are paying millions of dollars for transparency. What are you talking about? So we ended up getting that defeated, and I thought there is what I think is now a pretty good exemption. It's similar to what you described, Lucian. It's like I said, not ideal. Our position has always been that body camera footage is just like any other record, and you don't need a special exemption or special exemptions or special rules at all, frankly, for making it available to the public. We're in the minority in terms of that viewpoint, I think, particularly among lawmakers. But I think ultimately what we came out with was a pretty good compromise position that still allows members of the public, including people like us, to request body camera footage. The DC MPD has now started putting that footage, once it's requested, releasing it on its YouTube page, which I think is pretty interesting.
What about redaction? Because, I mean, I've heard horror stories, I guess, from Seattle about redaction, and elsewhere they're having some issues. We haven't had any issues yet, but, I mean, what have you heard about that?
So I think that, and this is kind of what I like, too, about the Tennessee legislature, I guess, showing some humility in terms of the technology, because the technology on redaction is actually changing very, very quickly. And this is an argument we made to the DC Council. They basically tried to justify, they had a whole host of reasons justifying a full-scale exemption, privacy, and a whole host of things. But one of their key factors, or one of their key complaints, was this is going to be too time-consuming because we have to redact this. The technology isn't there that will enable us to do it easily. We have to blur everyone's faces. We have to do X, Y, Z. We can't do it. And we presented a ton of tools that are available in the private sector, cheaply and inexpensively, that are basically home editing tools that you can use to redact things very quickly and very easily. Now, companies like Taser, I forget what they've changed their name to. They've changed their name to something, but Taser, yes, to something that I guess isn't associated with Taser. Taser is actually one of, if not the lead supplier. Most do. So there was one competitor for a little bit, but they've sort of been eclipsed by Taser, who provides not only the body cam equipment, but also all the software and data storage, and they're the one-stop shop for all the police departments for their body camera footage. They realized, and we've talked to some of the folks at Taser, they realized that they need to be ahead of the curve on this, and they're starting to build into their technology easier redaction tools. So my view on that is don't allow somebody to say redaction is too hard and takes too much time, because frankly that's an excuse. The technology is there.
The other thing I think for people in this room, in this community, that's maybe most important, is to get ahead of this issue. If it's not on the radar screen yet in your community, it probably is, because they hadn't rolled out body cam programs across Tennessee at the time this really got in the legislature, and that was helpful to some extent because the plans were still being formulated. But I mean, there are lots of moving parts. I mean, one that I still do not understand for the life of me is in Shelby County, our body cam footage is supposedly in the custody of the district attorney. Now these are police department records. What the hell is that about? I don't. Anyway, and so that of course creates a funding issue. Think about the funding required, not just to buy the stuff, but to maintain the stuff, to search the stuff, to produce the stuff, even if redaction is easy. And who controls that, who runs that, is probably going to affect what your likelihood of getting this stuff is down the road. So my advice is you should get in front of it if it's still an option. Anyway, but Frank, did you?
Yeah, I mean, real quick, because this is new since the last time we'll have been together. Many followed that there's a growing body of case law under the First Amendment that says that there is a constitutionally based right to videotape and audio record police doing police business in public spaces. And since y'all met a year ago, we've got two more circuits, the Fifth Circuit and the Third Circuit, that have weighed in, and we've now got, I think, a pretty overwhelming consensus. 4 circuits have said, yes, there is a constitutionally based right, and nobody has said to the contrary. Now, does that directly mean that there's a right to FOIA body cam video? It does not, but there's some very good, helpful language in those opinions that practitioners can use about the compelling interest that the public has in overseeing how police use their authority, especially when they're in a public place. I think it's really helpful if I were litigating for dash cam video, because dash cam video is always in a public place. The objection to body cam video is that a horrible, kind of nightmare scenario where you're in somebody's bedroom room and the body camera is activated. But you're never going to have your dash cam video is in somebody's bedroom. You got a bigger problem. But you're always going to be in a public setting, and so I think there's some good language in there that can be extrapolated. Can I do a shout out for one thing? Because Dave Coulier gave me this invitation before. I would love to work with y'all, and so would my successor Hadar Harris at SPLC, on passing some more of these laws that protect the independence of student journalists at the college and the high school level. We had our best year ever this past year. 3 statutes passed: Nevada, Rhode Island, and Vermont. That brings us to 13. I know a lot of the states in this room. There's a sponsor in New York. There's a sponsor in Texas, in New Jersey, and who else? Michigan. So I definitely want to talk to all of y'all about that and put you in touch with the folks that are working on. The website is New Voices US, newvoicesus.com, and we would love to have your help in trying to pass those. We're on a nice roll right now.
Cool. We haven't. Oh, go ahead.
I just want to add one thing to what Lucian said, which is to get in front of these bad body cam laws. I completely 100% agree with that. And what I might also suggest is to look for allies in places where maybe you wouldn't necessarily have looked before. I mean, I think if you, particularly given the sort of rash of police-involved shootings, there are a lot of organizations, I'm thinking Communities United Against Police Violence in New York, for example, that have been very active on the transparency front in getting access to NYPD police records and challenging assertions of the personnel records exemptions under FOIL. We've filed amicus briefs, pro-transparency amicus briefs in some support of some of their cases. I think these are organizations that they may not necessarily think that access to body cam footage is a critical issue, but when you talked with those organizations, I guarantee 100% that you can convince them that it is, and that you will have maybe a stronger, more diverse group of allies on a case like that, or on legislation that you might otherwise not have.
That's a hell of an interesting point. I mean, I've been noticing in our work new allies springing up in interesting places, and I mean, maybe it should go without saying, but maybe we'll say it, is on body cams. You know, there are a lot of communities in our state that they certainly feel that they're more directly affected than anybody else, and they have legislators. Certainly in Nashville, they have legislators, and they care. So that's not the normal issue, and most of these issues have. A number of our issues have morphed, in my opinion, in the last few years in terms of where we can find allies. So keep your eyes open. We're out of time, but maybe a question. Yes, in the back.
It's a quick one. I noticed you said you had a problem with state laws and getting the U.S. Supreme Court to take it up. Why not press the First Amendment civil rights issue on FOIA denials? Because if I can't get the information, I'm not free to speak about it.
Oh, it's a great one. I wish that we were not foreclosed on that, but the Supreme Court had this case a few years ago. VCOG will be painfully aware of this. This was a case involving, is there a constitutionally based right of access to government records that overrides these citizen-only requestor provisions? And the Supreme Court comes back and says, no, there is no constitutionally based right of access to government records, and therefore these statutes are constitutional. So they slammed the door pretty hard in our face on that one. I will say, because of this spate of recent rulings about about being able to videotape police in public settings, a lot of us do want to see if we can incrementally expand on that. You know, there may not be any generalized right constitutionally based of access, but this is how courts started, right? First we got access to the trial, then we got access to the jury selection, then we got access to civil proceedings, right? You eat the cookie a bite at a time. So it may be that we can take this precedent about videotaping police in public settings and build upon it, but you're going to have to do it a bite at a time.
Deborah Fisher, I cannot resist Deborah Fisher's question, or last question maybe. For the
last question, okay. What about photographing public records? Could that fall under it?
Yeah, you've already talked about our experience, so I'm going to not groan and
yeah, I mean, I will say your experience is actually quite unusual. The prevailing, I mean, the overwhelming trend is either by common law or by statute to make it legal to do that. What I would do, I would tell your client to get one of those TV sketch artists and go sketch the public records and do that a few times and show the sketch artist drawing of the records until they realize how ridiculous it is.
We're working on humiliation.
That could be a while before our guys, our public records custodians, realize how ridiculous it is. Join me in thanking Frank and Katie. This has been great. Thank you guys very much.